Welcome to Judicial Ways of Working, the podcast series produced by the Institute of Advanced Legal Studies at the University of London. My name is Carl Stychin, and I'm the director of the Institute. This series explores how members of the judiciary are working during the global coronavirus pandemic. I'm delighted to welcome Upper Tribunal Judge Elizabeth Cooke to today's podcast. Judge Cooke is a member of the Lands Chamber of the Upper Tribunal. She began her career as a solicitor and then left practice to study for an LLM at the University of Reading, which she then joined as an academic and was awarded a personal chair in 2003. As an academic, she published widely on property law issues and is particularly well known for her books, The Modern Law of Estoppel, The New Law of Land Registration, and the Oxford Clarendon title, Land Law. In 2008, Judge Cooke was appointed a law commissioner for England and Wales, where she served until 2015. During this period, she was responsible for the Commission's reports on property, family, and trust law. Judge Cooke has also been a Deputy High Court judge since 2013, sitting in the Administration Court and the Chancery Division. Lizzie, welcome to the podcast.
Thank you very much, Carl.
A difficult question to start with, but can you describe your everyday professional life as a judge to us as it was before the pandemic?
Well, it does seem like a long time ago. You mentioned that I'm an upper tribunal judge. I sit in the Lands Chamber, where we do mostly high-value property disputes, but some Housing Act appeals. And we're a very small chamber. There's just a handful of us, and that has flavoured my experience of lockdown. I also sit in the High Court, in the Chancery Division, the Administrative Court, sometimes in London, sometimes elsewhere. Daily life was, until recently, pretty much every day in London. I wasn't that keen on working at home. I enjoy the buzz of going to London, the excitement of legal London and all that goes on there, working in the Royal Courts of Justice, which is a fantastic place to work. It's a ridiculous Gothic building, and the pleasure of being with my colleagues and interacting with them and discussing with them. So it was a great life. It also involved trips around the country, because now and then we might do a site visit in Northumberland, and we might as well then hear the case in Northumberland, or on occasions I sit in the High Court in Leeds or Manchester. So it was quite a mobile life, quite physically active, as well as very much mentally active. So that was everyday life, really.
And to what extent was your judicial role previously enabled by technology?
Compared to now, the answer has to be not much. Obviously, we're all online. We have the recent e-judiciary system, which has made judges all a great deal more connected up with database resources, with library resources, and so on, and with information storage. But life was dominated by pieces of paper. Bundles were all in paper form. We occasionally did telephone case management hearings in circumstances where it really wasn't sensible to drag people across the country for a half-hour directions hearing. And I really did not like telephone hearings. I find it very difficult to recognise voices on the phone, and faced with a sightless void where I've got voices coming at me, I find it difficult to work out which barrister is talking to me, and also not knowing who's online. You can get halfway through a directions hearing and then realise actually there's somebody else here, isn't there, because somebody refers to someone. So I didn't like telephone hearings. We obviously had quite a lot of information technology, but all the material that you look at when you're conducting a hearing was on paper.
Right. So the obvious next question is, how has work changed for you as a result of the pandemic? How was the transition managed?
Well, how has it changed and how was it managed? On one level, it's hugely changed. On another level, it hasn't changed at all. I'm doing exactly what I was doing before, but in a different place and in a different way. And the experience of change was very much flavoured by the fact that we are a small chamber. We live in the northwest corner of the Royal Courts of Justice in a little enclave there with some quite nice offices. A week before lockdown, when it was obvious that it was going to happen, we got together and learnt how to use Skype. And we had a couple of Skype meetings. And on Friday, the 20th of March, I did what I think was the very first upper tribunal Skype hearing before we had to. And it was done largely by cajoling those involved. Not so much our staff, because they took to it very well, but barristers who were very unfamiliar with this and were only across the road and didn't actually at this stage want to do it remotely. And I was saying, come on, we're going to have to do this. Let's learn how to do it. And then we had a very successful Skype hearing on Friday the 20th before we actually had to. And we had spent the week as judges essentially helping each other, you know, trying to get the right level of IT support where we couldn't solve problems. Some of us are more IT savvy than others, and we ended up by the end of the week with everybody confident with Skype. And then we went home. And you see me here in my conservatory with the tomato plants. And this is where I work, and I have come to like working at home very much because I had to. I've evolved a useful space within the home that I'm comfortable with and have enough space in. When I have a hearing, I go upstairs to the study where I have a nice sort of book-lined wall, but it's a very small room that I don't normally like working in. But you know, it's one where I can shut the door, make sure the family knows I can't be disturbed, and that has worked very smoothly. We're all very keen on having the right background to our Skype or whatever. What gets me out of bed in the morning now is not the excitement to travel to London and not the pleasure of face-to-face meetings with my colleagues, which I do still enjoy, I do miss, but I still have incredibly interesting work. I've been very busy all along. We've had no let up in the work because we just stepped sideways and started doing it remotely. A few hearings had to be transferred to written representations, and that has been straightforward because we were already doing some on written representations. Most of our hearings have gone ahead. We have a full diary going forward. And, you know, I'm writing judgments. I need to think between paragraphs, so I go outside and talk to my potato plants or whatever. I have weekly Skype meetings with all the members of the Lands Chamber, so we get to see each other and actually are catching up weekly in a better way than we've ever done before. We meet one-to-one where necessary. 3 weeks ago, I spent the week in Leeds, in the High Court in Leeds from the comfort of my own home. So, you know, it has worked so much better than we all thought it would. I have now started going back in. We're not doing face-to-face hearings yet, but our staff are in, and therefore we as judges want to be seen to be going in and to interact with them. And also where we are using physical files, we need to move them back and forth. And going back into London is an adventure. I've driven in, having never driven in central London before, and I must say driving down Constitution Hill 4 weeks ago with not a car in sight was quite spooky. Since then, they put back the congestion charge, so I'm not doing it. So I've been in by train, deserted train carriages. I've walked across London to the RCJ, which is fine, but I end up walking 10 miles in the course of the day there and back and at this end. So 2 days ago, I used a Santander bike, which I've never done before. £2 for a huge amount of fun. So that was an adventure. I mean, this is all very, this is the micro aspects of the change. It's not necessarily important in terms of the administration of justice, but it gives you a flavour of how life has become different.
Are there any aspects that you found particularly challenging to judicial working remotely?
I think that the biggest challenge is the purely mundane business of internet quality, which is quite amusing since a major part of the Lands Chamber's caseload is the Electronic Communications Code, which is all about access to quality telephone services and the relationship between landowners and phone signal providers. Until a week ago, when people moved out, there were actually 3 full-time professionals working in my house, which meant a little bit of stress on physical space and also on bandwidth. Within a hearing, we do get problems with counsel or witnesses losing a connection or whatever, and I think we've just all learned to be patient. It's always soluble.
And are there aspects of the changes that surprised you, things that actually worked more effectively than you expected, or even felt like an improvement?
Well, you probably picked up already that a lot of this has been a surprise. At a most basic level, I mentioned how much I disliked telephone hearings. I'm surprised at how exponentially better a Skype hearing is than a telephone hearing. I'm surprised to find that an electronic bundle is much, much better than a paper one. We might have been juggling a dozen thick lever arch files on the bench, and now with solicitors learning rapidly how to deal with a hyperlinked bundle, I can just bounce from one end of a bundle to another. Another surprise has been that people other than legal professionals have found this a very good change. So at my hearing the other week, one of the witnesses was, in any disrespect, but he was of an age where you wouldn't expect him to be all that good with IT. He had an electronic bundle and a paper bundle. He said, no, the electronic bundle is so much better. And I said, 2 months ago, we would not have imagined that anyone would say that.
Are there also any aspects of remote working that give you concern? And I'm wondering how you've managed those aspects about concerning the quality of the judicial process and decisions.
Well, this is very much flavoured by the jurisdictions in which I sit, where largely we are dealing with money in the form of land. I don't sit in family law and I don't sit in crime, although I used to. And the challenges there have given rise to much greater causes for concern. Jury trials cannot be done remotely because it is not possible for a juror to sit at home. Family hearings have had to continue. I don't have direct experience of this, but I know that the family judiciary have given an enormous amount of very anxious thought to what can and cannot be achieved. And in a family hearing where you're dealing with what matters most to people in their lives, their family life, the absence of something so basic as eye contact, because it's difficult to do that with a laptop, let alone a phone. It all makes it so much more difficult to help people to know that they have been heard. So there are significant difficulties, I think, in both crime and family hearings. At the very other end of the scale, where I sit, we have been surprised at how well things have worked, and there has been a lot of goodwill and a lot of give from professionals who have just been relieved to know that we can continue to do business. And that's the key. At the end of the judiciary where I sit, we are doing business. It's not that difficult to carry on. That said, I mentioned that we do hear some Housing Act appeals. A small proportion of our caseload does deal with people's security in their home. And those are the cases where we're more likely to get unrepresented litigants, more likely to get litigants who can't manage Skype, or who don't have the ability to make their documents electronic. And in those cases, we've simply adjourned till September in faith that that's going to be possible.
So assuming at some point things go back to some form of normal, do you think that there are lessons that can be learned from this time as to how we resolve disputes? And I'm wondering, has your experience changed your views on judicial decision making?
Well, certainly on the potential for remote judicial decision making, yes, absolutely. I would not have believed 3 months ago that we would have achieved what we've achieved as effectively as we've achieved it. And I think I can fairly say that in the hearings I have conducted remotely, the remote nature of the hearing hasn't really made a lot of difference. I'm very surprised to hear myself saying that. Now, what I've been talking about so far has been very much my personal experience, because I know that you're looking for the time capsule of what was it like to be judging in the pandemic. Obviously, the bigger picture is the work being done by the senior judiciary, who have helped us to regularise the experience with guidance to be followed during the pandemic, and who are now working very hard, both on evaluating what we've done and in making plans for going back to normal. If there is ever going to be such a thing as normal, there has to be proper evaluation and learning from what we've done. And each jurisdiction is going to be different. The jurisdiction where I sit will probably go back to face-to-face hearings as a norm. Other jurisdictions may not do. It may work a bit differently. Think about a mental health tribunal, where the whole atmosphere is very, very different. And obviously the family courts and the criminal courts really do need, for the most part, to go back to face-to-face. I hope that electronic bundles are here to stay. The pandemic is worth noticing that it came at a point when we're in the middle of the HMCTS reform programme. Some courts have already gone paperless. The criminal courts, for example, have a fantastic electronic case management system, and you never see a paper bundle there. And it's been like that for 2 or 3 years. Whereas where I sit, all our bundles were paper. And I can't take a case home to work on if I have 10 lever arch files, whereas now I can. And electronic documentation and new case management systems are obviously going to be a huge blessing. Remote hearings, even in my own jurisdiction, will remain a possibility for example, case management hearings, where we don't need to drag people into court for a 1-hour directions hearing, or for cases where people have special needs and find it very difficult to travel, or where the actual location of the parties and the value at stake makes it not worth having people travel. I think that there are 2 things that I just want the system, if you like, to keep in mind. And one of those is the value of the courtroom. There is something to be said for people getting together in a space and facing each other. It's not fun, and it's not meant to be. But it is an awful lot better than the alternative, which is using our fists. I look around a courtroom and think this is what we do instead of fighting each other. It's what we do when more comfortable means of resolution have failed. And it's worth just keeping in mind the importance of physical presence in a room. The other thing is open justice. In the Royal Courts of Justice, I sit on the bench. I don't know who is in the room. There might be 2 or 3 rows of people. Some of them might wander in and wander out in the middle of the hearing. They are all welcome. I don't need to know who they are. They can attend, and they can attend anonymously. Now, what we've developed for Skype hearings is the court list goes up in public as usual, except people can't go and look at it in the Great Hall of the RCJ. They've got to look it up online. And anyone, as I understand it, is free to email the office and say, I would like to dial into that Skype hearing. And therefore, I have had Skype hearings recently where there have been a lot of people in the room, many of whom are professionals from firms who are not involved. For example, a very significant telecommunications case that I was doing, there were a lot of people watching, and I didn't stop to look down the list to see who they were. There is an interesting dynamic there, because anybody who was present and wants to know who is listening can do so. So it's open justice with a different flavour. Now, for some people, of course, wandering into the courtroom is not practicable. They're at the wrong end of the country and they can dial into a Skype hearing. So it may be that this will be a catalyst for having hearings that take place in person, but we may have lost our fear of live streaming. I don't know. I think there are a lot of lessons to be learned, and they will obviously be identified and taken forward at a much higher level than the one at which I sit. But there's a lot of very interesting stuff for the future.
Well, it sounds that you would believe that these changed ways of working may have a permanent impact on the judiciary.
I think so. I think so. Part of it was a change of which we were already in the process because of the move to paperless bundles, which was already happening. So to some extent it would have happened anyway, but I think, you know, we have perhaps emerged from this time as, I think we have realised how quickly we can adapt to change. And it's been different for every chamber. It's been, I think, more straightforward where I sit because we're a small group. It's not been difficult to shunt everything into a different way of doing things. Other chambers have different levels of urgency, different levels of emotion. So it's different. But I think we've learned a lot about adaptability.
And finally, do you have any advice, any judicial words of wisdom for those who are finding it difficult and a challenge to be working remotely in their jobs?
No, I don't. I have no words of wisdom, and I wouldn't presume to advise. And other people will have had, I think, a harder time than I have. I think what has kept a smile on my face is the gratitude for what has been possible. When we went into lockdown, particularly when it was obviously about to happen, I think I felt a great sense of loss. I felt, you know, what I love about my job is going. We'll never get it back. And actually, it's not like that. It has not, I think, been a time of loss in this respect. I know it has been a terrible time for the country and for the world. But a little glimmer of light has been the way that business has kept going, and I'm very grateful for that.
Well, on that note, Judge Elizabeth Cooke, thank you very much for joining us on Judicial Ways of Working. Thank you.
My pleasure. Thank you.